The ARCCA experts are one of the most, if not the most, important witnesses for the defense. And on Monday, they were questioned pretty heavily by the prosecutor in regards to their testimony and what they may testify to during this trial. Hi, my name is Sydney Rushing. I'm a criminal defense attorney. Now let's talk about it. This was a voir dire hearing of the ARCCA experts. And what voir dire is basically questioning of these experts about their testimony, about what they think they're going to testify to. It can also prevent them from testifying. Now, if you're wondering where the ARCCA experts came from, they actually came from a federal investigation, reviewed the Norfolk District Attorney Office's handling of Karen's case, and they testified in the first trial that the injuries that John received likely weren't consistent with the story that was laid out by the prosecution. And as we know, the prosecution is trying to show that the ARCCA experts and the defense team have a much closer relationship than they're trying to let on. And as we know, in a prior hearing, Judge Cannoni did chastise the defense. Not shockingly, things got a little spicy during the hearing itself. ARCCA expert Daniel Wolf was called to the stand, and Brennan immediately went in and started questioning about his relationship with the defense and their communications. And if you are wondering, Daniel Wolf is affectionately known as Crash Daddy. There was lots of questions about the court order and whether they turned over the communications that the court ordered that they had. And while Wolf did say that he didn't provide the communications directly to the court, he did provide them to the attorneys. Wolf also said that he wasn't able to receive these old text messages because they were with an old carrier. Brennan got down into the nitty-gritty, asking about the who, what, where, when, why, how of their communications with the defense team. Brennan asked Wolf about that call that happened back in March and regarding whether or not it was just about logistics, and Wolf said that he talked to them as if they were any other client who was going to retain them to testify. Brennan took a cheap shot and said, "So when did you become an advocate for the defense?" Which, of course, the defense objected to real quick, and Judge Cannoni sustained. Honestly, he's trying to act like his own witnesses aren't also advocates for his side and trying to cover up a cover-up, or at least that's what we've seen so far. He then followed up with, "Well, do you feel like an advocate for the defense?" Brennan asked if he discussed his findings over an ARCCA report with the defense. Wolf admitted that he deleted approximately 100 texts after the trial was over, and he said that that is typical of what he does. He discussed using the Signal app with defense, and he said that that was Jackson's preferred method of communication. And yes, we are talking about the same Signal app that our White House and our Department of Justice likes to use, talk about military attacks and, things like that. And as an FYI, Signal does not keep records. Brennan accused Wolf of being vague. He said, "When you had these conversations, why didn't you write them down?" And Wolf responded in the typical witness fashion of, "I have provided the court with everything in my possession." Brennan was really curious about the Q&As that Mr. Wolf sent over to the defense the day before their testimony. And he said that that's typical of what he does in cases because it helps the attorneys tell the jurors are the right questions to ask to explain what they do. And if you ask me, that makes perfect sense. Shoot, I wish some witnesses would come to me and say, here's some good questions, here's some answers, this is how this looks. I would love that. As long as they're honest, that's all that matters. He said he would have given the same information to prosecutors if they had reached out and asked, and of course, Brennan did not believe that in the slightest. And then finally, to wrap up his direct questioning, Brennan asked why a third member of the team didn't testify, and Wolf responded simply, "We have the same specialty and it would have been duplicative in nature. And if there's anything to know about Karen's case, is it is a long trial. We don't need any duplicative witnesses." Alessi then came up and cross-examined Mr. Wolf. His approach was obviously much nicer and much tamer. Wolf confirmed that he complied with the court orders. His conclusions have stayed the same. And interesting enough, the billing number for Karen's case was the same between the Department of Justice and then over to the defense team. There was a lot of questions obviously reinforcing that he followed the court orders. Wolf confirmed that he didn't know of any inducements from the defense to ARCCA for them to testify. And again, he doubled down on the question and answer section and how he does this basically every case. Wolf also testified how he was the victim of receiving hate mail because of his involvement in this case. He made it very clear that he's never made an untruthful statement in this case. Finally, they discussed moving their conversations to Signal, that he didn't have an issue with using it, and he wasn't aware of the background issues that were happening that caused for them to move over there to the app. Redirect, Brennan asked about the timing and creating the report. He specifically asked, "Did you know that there was a sequestration order in this case?" Wolf said, "I wasn't aware of that." Brennan said, "But you did in fact receive information about other witnesses' testimony, didn't you?" To which Wolf responded, "From the Department of Justice, yes." And then Judge Cannoni called a quick sidebar, and the next thing you know, Wolf was dismissed. Then the second ARCCA expert was called, and that's Andrew Rentschler. Brennan asked him about his prior communications with the defense, and he said that I had 6 text messages and 3 phone calls. He said he didn't discuss his testimony with the defense. He said he didn't talk with the defense over the Signal app because there wasn't a reason to. He also said that the Department of Justice shared some of what witnesses testified to, before his own testimony, and that he was unaware of a sequestration order preventing witnesses from knowing that information. Cannoni wrapped up his questioning basically by saying, if I ordered you to, could you have your report done by May 7th? And he basically replied, yes, I'll do my best. And that was it. Court then concluded for the day, and it looks like we'll be hearing from the ARCCA experts in the first parts of May, but we won't know until then. As a little side note, I do think it's a little weird how hard the prosecution is trying to keep these ARCCA experts out just because of the information they bring in is extremely important for Karen. It shows her innocence, or could show her innocence. And so for a prosecutor to be trying to keep that out, right, and obviously because it would hurt her if it didn't come in, it's a little weird to me. It's not really screaming justice, or we're trying to receive justice or get to the truth here, right? It's not screaming that when you're trying to keep out their defense and something that makes sense and you're trying to paint it as something that it's not. That's the recap on the ARCCA Experts Voir that happened, and I look forward to following along with you guys for the rest of this crazy retrial.